Good morning, everybody. Buenos días, señor Gramajo.
Good morning, Mr. Gramajo. Would you please read the statement you have in front of you? I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief. Thank you very much.
Good morning, Dr. Gramajo. How are you this morning?
Muy bien, gracias.
Very well, thank you.
I'd like to ask you a few questions, and just to set your testimony in its proper context. First of all, you have before you declarations, I believe 3 declarations you have submitted in this case. Can you please confirm for the tribunal that the declarations that are before you are in fact your declarations and that you ratify their contents here before the tribunal?
That is correct. I have 3 statements.
The contents of those declarations for the tribunal.
Yes, I do.
Dr. Gramajo, I understand from your prior testimony in this case and the declarations you have submitted that at one point you became the overseer of FEGWA. Is that true?
Así es, correcto.
That is correct.
When did you become the overseer of FEGWA?
February 6th, 2004.
You entered into that position as the overseer of FEGWA. Did you ask at any point in time for contracts with third parties to be reviewed by your legal staff?
Así es.
That is correct. I did that almost right after I started working with FEGWA.
Contracts that was reviewed by the FEGWA legal staff, the Contract 143 and its amendment, Contract 158, between FEGWA and Ferrovías Guatemala.
Yes, that is correct.
Did there come a time after you began your position as FEGWA's overseer where you received a communication, a letter from Ferrovías Guatemala requesting access to warehouses and some equipment pursuant to Contract 143 and 158?
That is correct. I received a letter by the general manager of Ferrovías Guatemala requesting access to some warehouses as well as the equipment inside.
R7 on the screen. Do we have the Spanish version that we can hand to the witness? Okay, I think what you're going to see on the screen there, Dr. Gramajo, is there's a version of it in Spanish and English, and I think you're now being handed a copy of the document in Spanish. First of all, could you identify this document for the record?
Así.
That is correct. This is a letter that I received signed by Mr. Jorge Sensa-Gastumi, General Manager of Ferrovías, dated April 14th, 2004. This is the seal indicating that it was received by FEGWA, and this is a letter in which he was requesting what I mentioned before.
To this request?
Así es.
That is correct. When I received this request, I indicated the legal department of FEGWA to examine the letter and to give me a legal opinion about this request. The legal department with FEGWA sent me the legal opinion about this request, and the answer for Mr. Sen included a copy of this legal opinion.
49, which for the record is a letter from Dr. Arturo Gramajo to Mr. Jorge Sen, dated 21 April 2004. And sir, before you on the screen, both in English and in Spanish, is a copy of a letter dated April 21, 2004 from you to Mr. Sen. Is this the letter in which you respond to that request that you received from Mr. Sen on 14 April 2004?
Así es, esta es la carta.
That is correct. This was the answer.
Could you just explain to the tribunal how you responded to Mr. Sen's request?
La respuesta.
The response by FEGWA, as overseer of FEGWA, was that it was not possible to give him what he had requested, and I also included the opinion of the legal department so that he could see the reasons why his request was not accepted.
R8, which is the legal opinion that was attached to this letter, and to which Dr. Gramajo just testified. Dr. Gramajo, we are now putting before you up on the screen document R8, which is the legal opinion number 47-2004, the same one referenced in your 21 April 2004 response to Mr. Sen. Is this the document that you attached to the letter response to Mr. Sen?
Afirmativo, así es.
Correct.
And if we could highlight the conclusion, for the sake of time, I'm not going to go through all of the document, but I would submit it to the tribunal for its consideration. And in this response, in the conclusion, is it correct that you, first of all, denied the request, or that you were informed by your legal department that you should deny the request made by Mr. Sen?
Así es.
That is correct.
Okay. And did the legal department suggest to you that you should deny, or tell you that you should deny the request pursuant to contract 143 and 158 until the irregularities specified in the contract and as set forth earlier in the body of the opinion were cured?
Así es, eso es lo que...
That is correct. That's what the legal opinion says.
After you sent this request to Mr. Sen, do you recall whether FEGWA and Ferrovías ever entered into any discussions, meetings, communications, whose purpose it was to attempt to cure the irregularities that were signaled to you by your legal department in relation to contracts 143 and 158?
Sí.
Yes. We started a series of conversations, of discussions at the offices of Ferrovías, Mr. Palacios and Pedro Mendoza Montano, one of the lawyers for Ferrovías, also attended the meeting. We held some meetings and we also exchanged some preliminary versions of a new contract for the use of the railway equipment.
Long, and given the time limitations, I would submit the tribunal to documents R80, R50, and R51, which documents speak for themselves, but they put into context the comments just made by Dr. Gramajo about the meetings that were had between the parties relating to Contract 143 and 158. Now, Dr. Gramajo, first of all, as a result of those negotiations and those meetings, did the parties come to an agreement to cure the deficiencies, the legal deficiencies or irregularities in Contracts 143 and 158?
We had several meetings, but we did not reach an agreement.
And did there come a time when you considered submitting Contracts 143 and 158 to President Oscar Berchet to have that contract and its amendment declared lesivo to the interests of the state of Guatemala?
Luego de tener
Upon meeting several times with the attorneys for Ferrovias in an attempt to draft a new contract, and given the failure to reach an agreement, we started to consider that it would be necessary to follow the path that would lead to the declaration of lesividad in connection with the contract. We had made an effort to come to an agreement with Ferrovias and draft the proper contract that would cure the defects that it had been there since the very beginning, but we were not able to reach a final agreement. Therefore, we had to continue with the process to finally get to the lesividad declaration.
Sir, why did you choose to pursue the lesivo path rather than other possible paths? Or let's see if you can answer that.
Since no agreement was reached with Ferrovias, we started to discuss with the legal department within the communications ministry. We presented our information and we started to assess and request other agencies their legal opinion. And that was the reason why the Ministry of Communications put us in contact with a respectable legal firm in Guatemala, Palacios and Associates, to give their legal opinion on the contracts. The result of this legal opinion was that the contract was lesive given the interest of the state. And based on this, we requested the Attorney General of the Republic to issue an opinion on the contracts, and the answer by the Attorney General of the Republic was that the contracts were lesivo to the interests of the state. But to further complete our impression that these contracts were lesivo, we requested again an expansion of their decision by the Attorney General, and once again we sent the Office of the Attorney General the request to have further clarification of their decision, and once again the Office of the Attorney General indicated that those contracts were lesivo to the interests of the country. By then we already had 2 or 3 previous decisions that also told us that the contracts were lesivo. After this, the legal department with FEGUA analyzed the legal opinions by the Attorney General's office, and based on this we decided to send the request for the lesividad declaration to the President of the Republic.
One additional set of questions, 2 questions, but in order to put in context, and again because of time, I would remit to the tribunal documents R13, C106, C108, R15, R17, R20 and R21, which put into context, again, the statements just made. These are the documents that put into context the testimony just given by Dr. Gramajo. Now, Dr. Gramajo, the tribunal's heard a lot about what happened since the president received your letter requesting that he declare lesivo the contracts. And so for the sake of time, I'm not going to take you through all of that story up until the time when the president issued the lesivo declaration. But I would ask you a couple of questions about the day before the lesivo declaration was published, on the 24th of August, 2006. Did you attend a meeting at which other government officials, Mr. Sen, on behalf of Ferrovias Guatemala, and some attorneys that were accompanying him were present?
Así es.
That is correct. I attended a meeting with the Ministry of Communications at their own facilities, and this was the meeting the day before the potential publication of the government agreement declaring lesividad. We had representatives of the government as well as Mr. Jorge Sen on behalf of Ferrovias.
There's been testimony in this case by Mr. Jorge Sen that during that meeting, a lawyer on behalf of the government, Miriam Lopez, held out a draft of an agreement and sort of, I forget precisely what the testimony was, but either placed it on the table and basically said words to the effect, either you sign this document or we will proceed to declare the contract lesivo, publish the lesivo declaration tomorrow. You were at the meeting. Tell the tribunal briefly, because we're basically out of time, what you recall about that meeting in respect to that allegation.
Bueno, no hubo.
There was no allegation. It is false that Miriam Lopez had any conduct like this one, trying to force the other party or to compel the other party. But I could say that given all the situation and the tension arising out of the possibility of having lesividad declared the next day, I would say that the environment, the situation was quite cordial and kind, and no one was pushed or forced to sign anything. But we asked Mr. Sen to examine the minutes, and I even remember that the minutes didn't include any names, but there were blank spaces to be filled by the parties. It was a negotiation, and once again, we had to negotiate to be able to fill out the contract, that settlement letter, but I deny the existence of any pressure or extreme pressure. It was not the case.
The tribunal to document C-44, which is the draft agreement that was discussed during that meeting. Thank you.
Mr. Foster.
Thank you, Mr. President. Hello again, Dr. Gramajo.
Muy buenos días.
Good morning, Mr. Foster. It's a pleasure to see you again.
Good to see you, sir. Let me ask you a few questions. You just testified that on August 24th, the document that was presented, you thought it needed to be negotiated, correct?
Sí.
Yes, that is correct.
And did you seriously think that that document could be negotiated in one day?
No puedo.
I cannot issue an opinion on that, because first of all, I am not an attorney, but the intention was that there were hours still ahead of us and we could sit down and negotiate, but no agreement was reached, unfortunately.
Okay, I'd like to go back to your letter to Mr. Sen that you discussed in your direct examination, which is Exhibit R49. Can you show me anything in your letter where you say there are legal defects in the contracts?
¿Podría ver la carta en español?
May I please see the letter in Spanish?
Give you the tab number. It's tab 36, and it should be in both English and Spanish for you.
La tengo en mis manos.
I have it with me.
And can you show me anything in your letter which says there are legal defects in the contracts?
En esta carta,
In this letter, that is the response, it says that it is not possible to allow them to have their request. And here it doesn't say anything about legal defects, but we did attach to this letter the legal opinion. Therefore, Mr. Sen automatically received the response letter with the legal opinion. Clearly, this indicated that he had received the information.
The opinion that you attached, it's R8, which is at tab 25. Can you show me anything in the legal opinion that says that the contracts have legal defects which affect their validity?
podemos llegar a la conclusión.
It says that the legal department of Ferrocarriles de Guatemala, FEGUA, based on the foregoing considerations, finds that it is not possible to grant the request filed by the representatives. Could you please speak a little bit slower? Yes.
Reading the answer, he was just asked to go a little slower, so if you could just be allowed to finish, please.
No problem.
The legal department of Ferrocarriles de Guatemala, FEGUA, based on the foregoing considerations, finds that it is not possible to grant the request filed by the representatives of Compañía Desarrolladora Ferroviaria Sociedad Anónima CODEFE. Therefore, the request shall be denied by this entity until the irregularities specified in contract number 143 as expanded through notarial deed number 158 authorized in this city on August 28th and October 7th, 2003 by Notary Public Claudia Mariela Marroquin Luter, are cured.
Is not what the doctor was reading. He was reading from the very last page of the document, the conclusion section.
Now, does that legal opinion anywhere state that contract 143 had not been entered into with the proper authorization?
Si me permiten leer el párrafo.
If you allow me to read the paragraph.
Y compañía.
It says Ferrocarriles de Guatemala, FEGUA. Ferrocarriles de Guatemala, FEGUA, en Compañía Desarrolladora Ferroviaria CODEFE, dated March entered into an usufruct contract that is included in document 41 authorized by Marco Tulio Cornejo Guarroquin, which was not approved by the executive agency. Since this was not approved, and also to find a solution to this, Ferrocarriles de Guatemala, FEGUA, and Compañía Desarrolladora Ferroviaria Sociedad Anónima, CODEFE, entered into a new onerous usufruct contract for the railway equipment included in Public Deed 143, authorized in this city on August 28, 2003, by Claudia Mariela Marroquin Luter, which was expanded by Deed 158, signed in this city in October 2003, also by Notary Public Claudia Mariela Marroquin Luter. And then it says Ferrocarriles de Guatemala, FEGUA, is a decentralized autonomous public entity governed by the provisions of its organic law embodied in Decree number 6072.
Reading the letter, I ask him a very simple question. Can he show me anything in that opinion where it says that contract 143 had been entered into without proper authorization?
Just for the record, I'm sorry, he's not a lawyer. The letter says what you're asking, so maybe you could direct him to the appropriate paragraph, Alan.
I don't think the letter does say what I want to know. Can he show me anything? He said that legal opinion put FVG on notice of the legal deficiencies in the contract, and I want him to show me what the legal deficiencies in the contract are. Can he show me where it says that it was entered into without proper authorization? And then when we get through with this, I'm going to ask him, what are the legal deficiencies in contract 143? So now he knows where I'm going. But let's get an answer to this question first.
And you know, I remit this to the tribunal. He's not a lawyer. And I'm not objecting to the question, okay?
Well, but then why don't we get him to answer it?
That's fine. I mean, I can clean it up on redirect if you'd like. The letter says what he said it says.
Can you show me anything that says that contract 143, not contract 41, but contract 143 was entered into without proper authorization?
Just a moment. I'm looking for it. In the third paragraph of page 2, it says, A, that the goods are not part of contract 143 under deed 158 authorized here in this city in August and October by Notary Claudia Maria Marroquin Luter. B, given that the assets are property of the state, Ferrocarriles of Guatemala shall not deliver them to third parties unless the applicable procedure is complied with and a favorable opinion is rendered by the executive through the State Assets Department and the General Accounts Controller's Office. Slower, please. Yes. A, the requested assets are not part of the railway equipment list described in contract number 143, as expanded by notarial deed number 158, authorized in this city on August 28 and October 7, 2003, by Notary Claudia Mariela Marroquin Luter. B, given that the assets are property of the state, Ferrocarriles de Guatemala shall not deliver them to third parties unless the applicable procedure is complied with and a favorable opinion is rendered by the executive branch through the State Assets Department and the General Accounts Controller's Office. Can I go on? There's something else about this. C, contract 143 as expanded by notarial deed number 158, authorized in the city on August 28 and October 7, 2003, by notary Claudia Mariela Marroquin Luther, show irregularities as noted in opinion number 40 DJ classification of March 31st this year, since it provides for the disposition of assets that are the property of the state of Guatemala without any authorization, as if those assets were owned by private legal entities. Such circumstance must be redressed as soon as practicable.
Did you provide a copy of the referenced legal opinion to Mr. Sen? I believe that's a question that can be answered yes or no, Dr. Gramajo.
No recuerdo.
I don't recall.
Is there anything in your letter or in the legal opinion which says that the contract 143 or 158 are lesivo to the interest of the state?
En esta carta,
In this letter, I don't see the word lesivo. However, the term started being used later on. If I am allowed to clarify, one cannot adduce that Mr. Sen had no knowledge of the fact that these contracts had defects that needed to be cured.
That's now my last question on this document. What are the defects in contract 143 and 158?
Question that calls for a legal conclusion. The doctor at all times had legal counsel. He testified on direct that he was advised by legal counsel and submitted letters to the president and others based on that legal advice. I think it's not a proper question for this lay witness as to what the legal defects were per se. We have a number of documents in the record that establish what the legal defects were.
The witness should answer in his own understanding what the legal defects of the contract were.
Can I ask for clarification in connection with this? I can answer as on the basis of what I understand, not necessarily based on this letter.
Legal defects.
Sí.
What was your understanding of these defects?
los defectos.
The legal defects, well, the most important ones were that in 143 and in its amendment 158, which is the usufruct of railroad equipment owned by Ferrocarriles de Guatemala, well, these were never approved via an executive resolution. This, according to what the lawyers have indicated to us. The contract referred to the bidding terms, but the bidding terms mentioned there are those related to contract 41, usufruct of railway equipment, and that contract had been entered into years back. It wouldn't be logical for bidding terms to be used of a contract executed many years ago for a contract for the usufruct of railway equipment. The bidding terms of the first usufruct contract provide that the contract must be executed by the government notary, and it must be authorized by an executive resolution of the President of the Republic. 143 says that that authorization is not necessary. On the basis of the opinion of lawyers, This is not correct, and that is one of the main defects that Contract 143 has, and the amendment, and that is also present in the amended Contract 158.
Is there any other, to your understanding, is there any other legal defect other than the failure to be approved by executive resolution?
To the extent that is characterizing the witness's answer that he just gave, I think that's a mischaracterization of his answer.
His exact words were, it was never approved by executive resolution. I wrote them down when he said them.
There were many other things he said.
I understand that there always are, but those were his exact words. Now, to your understanding, is there any other legal defect in contracts 143 or 158 other than the lack of approval by executive resolution?
Counselor, you are asking me about legal issues. I am not a lawyer. I would not be able to answer your question as a lawyer. If you asked me a question in a different manner, perhaps I would be able to answer it, but you were asking about legal terminology. I don't handle legal terminology. I'm not a lawyer.
Yes, sir, but I'm just asking you, with all your conversations and the many legal opinions that you received and that you sent to the President of the Republic when you were asking him to declare lesivo, just based upon your understanding, was there any other legal defect in these contracts other than the lack of approval by executive resolution?
Yes, if we can look at the letter that I sent to the President, the letter states the problems that the contracts had.
Do you recall what those were?
I would like to see the letter that I sent to the President of the Republic.
Helps, Alan. That's R21.
Okay, let's put up R21. I don't have a paper copy. Can you see it on your screen?
Sí.
Yes.
I'd be able to see an English version, please, and do you know which tab this is under?
It's not in the cross-examination binder, but we'll find it for you. You've got it. Good. Thank you, Natalie. So now, looking at your letter to the President, what is it you say the legal defects in contracts 143 and 158 were?
Por favor, podría.
Could I please see that on the screen? Can you maximize it?
A version of it, unfortunately, it has a little bit of highlighting, but it's in larger print. I think the version he's just been handed has such small print, he's going to have difficulty reading it. If you don't have objection, I can give him this.
It's fine.
Okay, just to move things along.
Surely.
Okay. Bueno. Esta es una carta.
This is a letter sent by me in my capacity as overseer of FEGUA to the President of the Republic of Guatemala, Mr. Oscar Rafael José Perdomo. Sí, muy bien, eso lo sabemos. Simplemente indíquenos
what are the legal defects that you asserted in your letter to the President with regard to contracts 143 and 158.
Bueno,
very well. Paragraph 2 said the contract was not awarded as a result of the bidding process as required by the government contracts law. The terms of reference, parenthesis, established in November 1997, were used for the severance of Contract 41, authorized in this city on March 23, 1999, by Notary Antonio Cornejo Marroquín, which never came into force because the President of the Republic failed to approve it, and it was terminated by mutual assent of the contracting parties under the contract. We hereby request to be declared as injurious to the state interests. Section 1 of Contract 143. Note that even when the terms of reference of Contract 41 as mentioned in Contract 143, the conditions of such bidding process were not applied.
Paragraph says, would it be fair to say that the first paragraph says that the contract was not awarded pursuant to a public bid?
I'm sorry, I'm going to object. It says a lot more than that. He's just read it into the record.
Skip the question, Mr. President. It speaks for itself. Okay. How about, is there any other thing in your letter that that you advance as being illegal about contracts 143 and 158?
In paragraph 4, it says, Contract 143 contains several irregularities, namely, A. FEGWA's obligation to grant any new or used equipment or spare parts in usufruct to the selected entity. B. The usufructuary is authorized to move the equipment outside the national territory for the term it deems necessary. C. The usufructuary does not undertake to return FEGWA's equipment which has been designated cultural, historical property, nor the waste material, scrap. No prohibition is imposed regarding the usufruct or the equipment. E. The contract relieves the usufructuary of any liability. F. The contract provides that the usufructuary may remove component parts of a piece of equipment to use them as replacements in another equipment. G. The contract is valid for a term of 44 years, 8 months, and 25 days. H. In consideration for the onerous usufruct of the equipment, which forms the subject matter of the contract, the usufructuary undertakes to make an annual payment to FEGWA of 1.25% of the net freight turnover for such equipment. No method was established for calculating the amounts charged for freight services, and FEGWA is not allowed to participate in the prior determination of said freight services.
quiere.
Mr. Gramajo, please go slower. Would you want me to repeat this paragraph? No. No, please don't.
Se modificó.
I. Sections 7 and 19 of Contract 143 were amended by Contract 158, authorized in this city on October 7, 2003, by Notary Claudia Mariela Marroquín Luther, to include the valuation of the property subject to usufruct and a list containing itemized prices which were agreed at the discretion of the contracting parties, without indicating the source of the value assigned to each item or requesting an appraisal of the property, and without taking into account the importance and historical value of the property which has been designated cultural property.
Perdón.
Excuse me. There is another defect that is to be found in this letter. May I go on? Even though the subject matter of the contract involved the disposition of state property transferred under onerous usufruct to a private individual, the contract was treated as if the state were acting as a private person, in violation of constitutional and other rules governing the transfer of state property and public procurement procedures.
My first question is, you never sent a copy of this letter or anything like this letter to Ferrovias, isn't that correct? Please answer.
No. No.
Thank you.
No.
Looking at paragraph 4, items, yes, blow it up so I can see the, items A, B, C, D, E, and F, and G were all included in in contract 41, weren't they?
No tengo a la vista.
I don't have contract 41 before me. I would not be able to say whether they're included in 41 because we are making reference to them in this letter.
Okay, and item H is not correct, is it? The 1.25% was on gross freight revenues, isn't that correct?
No le puedo contestar la pregunta porque
I cannot answer the question because I do not remember that.
Now, going back to item 1, the new bid, which I think is in paragraph 2, the issue of the bidding process, why didn't you solve that problem by having a new public bid?
Probably there would have been other bidders in that new bidding process. That is the only thing that I can think of right now. If a new bidding process had taken place, perhaps some other company would have been able to become a bidder there.
How did that harm the interest of the state to have a competitive bid?
On the basis of what the attorneys told me, the public bidding process was a requirement for these kinds of contracts.
Okay, looking at the issue of executive approval, which I think is in paragraph 3 of this letter, which you didn't read to us, but my question to you is, why didn't you just get it approved by the executive?
Are you asking me about 143?
Why didn't you just get the president to approve contract 143 and solve the problem?
Counselor, because 143 states that there was no need for authorization by any other higher authority. So it would not have been logical for me to ask the president to provide authorization for a contract of usufruct of railway equipment when the text of the document says that no approval is necessary by a higher authority.
yo enviarle al presidente.
I cannot send the president a request which is automatically incorrect. The contract states that there is no need for a higher authority to approve it.
But you disagree. You thought that was an irregularity in the contract. So why didn't you just solve the irregularity by getting the president to approve it?
Because I could not, I repeat, I could not send the President, well, 143, the use of a contract, says, it's not that the approval is unnecessary by the President of the Republic. So, well, I mean, I could not send it to him because it would have been a contradiction. It would have been a contradiction for me to ask the President to authorize a contract when the language in the contract says that it is not necessary for a higher authority to approve that contract. That is to say, the President of the Republic is not to approve that contract.
How can it be harmful to the interest of the state that the contract doesn't have a requirement for presidential approval, but you could have gotten it approved by the President? Doesn't that solve all of any potential harm to the state?
I'm sorry, that's assuming facts, not in evidence.
He can clearly answer this question.
No, he can't. That's not an unfair question. It's assuming facts, not in evidence. He has to ask a different question.
Could you rephrase it?
If you contended that this contract should be declared lesivo because it had not been approved by the President, why wouldn't you just ask him to approve the contract?
Counselor, I think my answer would be redundant. The language of the contract, and if you would be so kind to read it, you'll see it says that it is not necessary for the President or for a higher authority to approve the contract. If the language of the contract states that, then it would have been contradictory on my part to send the President a request for him to authorize the contract when the language in the contract says that no authorization by the President is necessary.
Why didn't you just simply ask Ferrovias to renegotiate that clause in the contract to require presidential approval and then go get it?
The answer is as follows. We commenced negotiations with the lawyers of Ferrovias to prepare a new railway equipment user contract that would not have the defects that had been identified. Drafts were exchanged of this new railway equipment user contract. Regrettably, we were not able to reach an agreement. The will to negotiate the new agreement, if you let me, you're asking me why we didn't reach an agreement. Well, we tried to negotiate with Ferrovias. However, like in every negotiation, sometimes you can reach agreement and sometimes you cannot. So,
excuse me, sir. Can you show me any piece of paper that you exchanged with Ferrovias where you ever said, we got a problem with this contract because it provides that it doesn't require presidential approval. We can solve the problem if we just change that term. Can you show me any time you ever said that to Ferrovias?
Mr. Chairman, I would ask that the witness not be cut off in the middle of an answer. If you could just ask Mr. Foster to let the witness finish his answers, please.
I would like to ask that the witness answer sufficiently briefly that I can ask him a few questions before the end of my hour.
Senor Gramajo.
Mr. Gramajo, try to be succinct in your answers because we don't have a lot of time and the lawyer has very little time to ask questions.
No recuerdo exactamente.
I don't have the documents before me and I don't remember exactly their numbering, but there was an exchange of draft contracts with Ferrovias. The first draft contract was basically a copy of contract 143. FEGWA objected this, and you can see on the drafts my handwritten notes requesting that that clause be changed so that the contract is approved via an executive resolution. Those drafts are there. We tried to prepare a new contract with Ferrovías that included these conditions so that the President of the Republic could approve the contract. However, we were not able to reach an agreement in these negotiations. There were differences amongst the parties, and like in every negotiation, sometimes you reach agreement and sometimes you don't.
Yes, sir, you've said that several times. Are you telling us that there is a document out there where you ask that the contract 143 be changed to require presidential approval so you could go get that presidential approval? Is that what you're telling us, sir?
There are contract minutes and some email exchanges between FEGUA and Ferrovías related to the meetings we were holding. And
simple question that can be answered yes or no. Are you telling us that there is a document out there where you requested that Contract 143 be amended to require presidential approval so that you could go get it? There either is or there isn't. Now, please answer me yes or no.
the answer is I do not recall.
That's fine.
He's cutting off the witness. I mean, you know, with all due respect, the witness was trying to answer the question. Now, Alan,
it's necessary to cut the witness off.
No, with all due respect, you're asking him questions that are important, and he needs to be able to give his full answers. You should not be cutting him off. That's improper.
He said he didn't recall, excuse me, and therefore there can't be any further answer.
No, that's not true. I would ask the President to please, again, it's my second request, to please ask Mr. Foster to not cut the witness off in the middle of his answers.
I will ask you not to cut him off, but I also will ask the witness to respond as succinctly as possible and as straight as possible.
I'd like to turn to another topic, Dr. Gramajo. I'd like to direct your attention to the Squatter Commission that was formed by the Ministry of Communications in January 2005. You served on that commission as FEGUA's representative, correct?
Sí.
Yes.
And Mr. Hector Pinto also served on that commission, right?
Así es.
That is right.
And you understood that Mr. Pinto was representing the sugar industry and the Ciudad del Sur project when he was serving on that commission, correct?
Sí, el señor Pinto se presentó.
Yes, Mr. Pinto introduced himself as a representative of the agro-industry of the southern coast, particularly of one company. We didn't know Mr. Pinto. We didn't know his background, but he did participate.
Ciudad del Sur is owned by Mr. Ramon Campollo, didn't you?
No.
No, I did not know that Ciudad del Sur was a project that was owned by Mr. Ramon Campollo. Mr. Campollo's name wasn't mentioned in the course of the negotiations of the Railway Commission.
You know that Mr. Campollo is in the sugar business at his Madre Tierra sugar mill, don't you?
No, no.
No, I don't know that. I'm not aware of that.
I guess you're going to tell us that you didn't know that Mr. Pinto represented Mr. Campollo in business matters either. Is that correct?
No.
I did not know that Mr. Pinto was a representative. Indeed, Mr. Pinto never mentioned Mr. Campollo in the course of the negotiations. According to my perception, I would like to clarify that according to my perception, Mr. Pinto had been invited to participate by Mr. Jorge Sen. That is what I perceived at that time. But I never found out, I never had knowledge that Mr. Pinto had a relationship with Mr. Campollo, who, of course, I don't know. I've never even seen his photograph.
The object of the Squatter Commission was to design a plan to relocate squatters occupying the South Coast Railway right-of-way in order to facilitate the rehabilitation of the South Coast Railway, correct?
Así es.
That is right, correct.
The Squatter Commission was needed because FEGUA had not promoted or requested the eviction of squatters. Isn't that right?
Es
This is partially incorrect. I can tell you that during my period as overseer of FEGUA, we carried out at least 2 massive evictions of the squatters who were in the right-of-way, the railroad right-of-way. And there's record of this in some press reports where FEGUA authorities, well, we were accompanied by the National Police of Guatemala, by the judge, by the Commission on Human Rights, and even on 1 or 2 occasions by Ferrovia's attorneys. And we carried out massive evictions of squatters on the South Coast. Those happened, so this means that we were concerned about the squatter issue. Indeed, if I may, indeed, FEGUA had a small office with 1 person in charge of addressing the issue of the squatters.
You were the FEGUA overseer on September the 13th, 2004, weren't you?
así es.
That's right.
Didn't FEGUA issue a press release as of that date admitting that they had not promoted or requested the eviction of squatters?
No recuerdo que haya sido en mi época.
I don't recall that it was during my term that that happened.
C-76.
Alan, could you let us know which tab number?
Tab 13. Thank you.
Okay.
Now, you as overseer authorized this press release, didn't you?
No. Y le voy a decir,
No, and I'm going to tell you. I'm recalling this right now.
si usted se da cuenta,
If you notice here,
siquiera el logotipo
the logo of FEGUA doesn't even appear. This was in keeping with what we realized at the time was an apocryphal publication. It was a publication that was done by a person who had nothing to do with FEGUA. Indeed, you can see my name doesn't appear anywhere. Plus, I recall precisely that this publication took us by surprise. That is to say, the staff and officials or officers of FEGUA were taken by surprise. We did not do this, make this publication.
So you're saying it's a fake, basically.
la publicación existe.
The publication exists, but it was not published by FEGUA.
Regardless, it does say in it that FEGUA has not promoted nor requested eviction of any of the settlement groups that currently occupy the right-of-way, right?
Eso es lo que dice este comunicado.
That's what this press release says. Nonetheless, we didn't publish it.
There were approximately 4,000 squatters occupying the South Coast right-of-way, weren't there?
No recuerdo.
I don't recall the exact number.
The Squatter Commission did develop a plan to remove the squatters and relocate them, correct?
Así es.
That is correct.
The plan was never implemented, was it?
No se ejecutó en el marco
It wasn't implemented in the framework of the project for rehabilitation of the Southern Railway. We did carry out some evictions of squatters along the railway right-of-way. But in the framework of the Commission's work, there were no evictions. Planning was done to be able to carry out the evictions once the conditions were present. That is to say, and if I could elaborate,
simple question, and that was that the plan wasn't implemented, and you answered that it was not. So I think that's adequate. It is true, is it not, Dr. Gramajo, that the reason the plan wasn't implemented is that the government didn't want to pay, or didn't have, or didn't want to pay the money that was necessary to build the housing so the squatters could be relocated. Isn't that right?
that is not correct.
If Mr. Valenzuela was the chairman of that commission, wasn't he?
Así es.
That's right. Mr. Valenzuela, Hector Valenzuela, was appointed secretary of that commission by the Vice Minister José Luis Gándara. That's what I recall.
Mrs. Mabel Hernandez was on that commission, wasn't she?
La señora
Ms. Mabel Hernandez was not someone who I knew well. I met her at the meetings of the Railway Commission.
So if they testified to this tribunal that the reason that the plan was not implemented was because the government didn't have the money, you just wouldn't agree with that, correct?
no estoy de
I don't agree. That's not true.
The money to build housing for the squatters and remove them.
No.
No. If I can elaborate to explain my answer.
I don't think it needs any elaboration, sir. Let me just ask you another question. Was it also a part of the plan that was developed by the commission that a census would be done of the squatters?
Así es.
That's right.
The census was never done either, was it?
Yo quisiera
I'd like to clarify, because in the context of my statement, one finds the answer to the attorney's concerns. First, I'd like to tell you that, in effect, in the Railway Commission, Mr. Oscar Bautista and Ms. Mabel Hernandez were invited as consultants. Supposedly, they were specialists on the issue of eviction of squatters. And they were contacted to carry out a census. They drew up a census plan which included any number of situations which, when they gave us the total price for carrying out the census, was extremely high cost. And we, the institutions who were attending, didn't have that. Indeed, I would like to tell you that Mr. Sen, a personal oral comment he made to me, was that he considered that it was too costly, too expensive, the census project, that is, as being proposed by Ms. Mabel Hernandez and Mr. Oscar Bautista. It was a very high sum. I don't remember exactly how much, but included purchase of vehicles, purchase of bicycles, and so on and so forth. So, an effort began to find some other option. Initially, I asked the financial department of FEGWA to indicate to me how much money FEGWA could contribute to such a census. And the finance people told me that we had 150,000 quetzales available, which was not enough for carrying out the census. So, and this is important, I ordered the FEGWA staff to carry out a census, and the FEGWA staff carried out a census in a space of 8 to 10 days. And there's a presentation that shows the results. Excuse me, but I ask once again that you give more concise answers. Okay, thank you.
You tried to get Ferrovias to put up the money for the census, didn't you?
No.
No, that's not so.
When Mr. Sen told you he thought the price was pretty high when you asked him to put up the money?
Le aclaro.
I clarify that I did not ask Mr. Sen for them to put up the money. What I did was to state in the meeting that FEGWA had 150,000 quetzales. We never asked anyone else to put up money.
Let's turn to another subject quickly if we can cover it. In your statement, you have asserted that Ferrovias breached Contract 402 by not completing Phase 2 of the renovation of the railroad, correct?
Sí.
Yes.
Also allege or assert that Ferrovias breached that contract by not beginning and completing Phase 3 of the railroad rehabilitation, correct?
Así es.
That is right.
Do you not, sir, that FEGWA overseer Manera wrote to Ferrovias acknowledging that Ferrovias had met its obligations with regard to Phase 2, don't you?
Sí.
Yes, that is right. I learned of that letter.
You know that he also wrote to Ferrovias stating that it was impossible for Ferrovias to renovate Phase 3, correct?
No recuerdo.
I don't recall whether it was a communication between Mr. Minera and Ferrovias or if it was a communication between Overseer Salceño and Ferrovias. In effect,
okay, so you later became aware of these letters, right?
Claro que sí.
of course.
You did not write Ferrovias revoking those letters or telling Ferrovias that those letters were wrong or anything of the sort, did you?
I did not write any note to Ferrovias in this regard. Nonetheless, Mr. Jorge Sen sent a note to Vice Minister Roberto Diaz in which he set forth some of Ferrovias's concerns, and I was copied on that letter. Nonetheless, I never received it. Vice Minister Diaz sent me the letter for me to make a comment on it. I sent him a comment on behalf of FEGWA. And we always spoke well, on several occasions, and in that note it says that Ferrovias, in our view, even though there were letters or communications indicating that Ferrovias had completed the second phase of rehabilitation, in our view, that second phase never was rehabilitated. While it's true that there was a protocol act which inaugurated the rehabilitation work, the truth, and all of us who have seen the railway in Guatemala know this, the truth is that nothing, absolutely nothing was ever done in terms of rehabilitation in Phase 2 except for the small stretch of the from Chiapas Mayav, Mexico to the rail station in Guatemala. But rehabilitation work, it didn't do any. And
rail service was offered on that segment. Is that not correct?
In which segment are you asking me about?
Just talking about. Rail service was offered on that segment. Is that not correct?
En ese tramo,
there were just about 1,500 meters that operated on that segment. The Mexican rail would enter, come in to leave cargo at the Tecún station in Guatemala. But if I can elaborate, may I, very briefly? It is illogical for a state to grant usufruct to a country to rehabilitate its entire rail network and for only a small part to have been done, and to leave the rest of the right-of-way as idle.
Thank you, sir. If I'm out of time, I'm out of time.
No,
Oh.
I'm saying just continue.
Oh,
because
thank you.
I
Thank you.
intervened because
Thank you.
was asked.
Yeah, I believe your answer was that rail service was offered on that segment, correct?
Mischaracterizing his testimony.
In that case, he didn't answer the question. Was rail service offered on that segment, yes or no?
By whom, Alan? By whom?
By Ferrovias, through any instrumentality, was rail service offered?
Yes, there was rail service, but it wasn't provided by Ferrovias. It was provided by another company.
From the two overseers concerning phases 1 and 2, those were official letters of FEGUR, weren't they?
Alan, just to help you, you said phases 1 and 2, and you were asking about phases 2 and 3.
Thank you very much, David. The letters concerning phases 2 and 3 that we have just been discussing, those were official letters of FEGUR, weren't they?
Yes, that is true.
To this day, never been revoked, have they?
No.
No, they have not been revoked.
Throughout, FEGUR received and accepted the canon payments pertaining to the railway equipment contract. Is that not correct?
Yes, that is right.
Accepting those canon payments, FEGUR never attached any reservations or said, we're accepting them under protest or anything of that sort. Isn't that correct?
I can clarify.
Please, and
Bueno,
then you can,
sí, pero tengo
clarify.
Antes de aclarar,
Before clarifying, well, you still haven't said anything that could be clarified. So please give a direct answer to the question, and if after that you need to clarify something, you can clarify it briefly. Yes, FEGUR received a canon payment for use of the rail equipment.
Received that canon payment, you did not receive it under protest or with reservation or with any declaration that you were reserving any rights, did you?
Así es.
That's right.
Further questions, Mr.
¿Puedo aclarar?
May I make a clarification?
Okay.
is I think if whatever council has the right to have a redirect here, and Mr. Horta.
My first question is, please clarify whatever it is you wanted to clarify in relation to Mr. Foster's question.
La pregunta.
The question as to why the canon payment was accepted, is that what you're talking about?
Bueno.
The canon payment was accepted by FEGUA because there were letters for authorization of use of the railway equipment that had been issued by prior overseers. And logically, Ferrovias was using the railway equipment that was FEGUA's property. And it was illogical for it to use it without making any payment in that respect. But the payment was based on the letters of authorization that had been issued by prior overseers.
Did you ever yourself emit one of these letters authorizing the use of the equipment?
No.
No, I didn't issue any letter because the prior letters were in force.
You were asked why you didn't submit contract 143 and 158 to the President for his approval. My first question is, were you told by your legal advisors that that contract was illegal?
Sí, así es.
Yes, that is right.
Have submitted a contract that you were told by your lawyers that it was illegal to the President to be approved?
Definitivamente.
I clearly could not present to the President for his approval a contract that was illegal. That was contradictory. I couldn't. Moreover, we must bear in mind that the President of the Republic is an attorney who knows the law, and I could not put myself at risk of making a fool of myself by sending him a contract that was illegal.
Shown a press release that you have testified before this tribunal was not a press release that was issued by FEGWA. That's document C76. The subject of the press release was whether or not FEGWA had conducted any evictions of squatters on the right-of-way. And my question is, did FEGWA conduct any evictions of squatters on the right-of-way while you were FEGWA's overseer?
Afirmativo.
Yes, we did carry out at least 2 massive evictions. This means...
He's already answered this question.
Well, this is redirect. I'm allowed to ask him about it. He was shown a press release and cut off in his answer.
I think he should, of course, he should answer. He should finish the answer.
Okay.
Very well, FEGWA carried out at least 2 massive evictions. And when I say massive evictions, there were at least 200 or 300 people in the right-of-way. And we did this at certain risk because these people generally could become violent. The FEGWA personnel collaborated in dismantling the precarious homes that had been constructed in the right-of-way. Indeed, FEGWA's attorneys were present, likewise the judge, the Human Rights Ombudsman interim at that time, and Ferrovia's attorneys who drew up an act in this regard. So we were concerned, in my time as overseer, we were concerned about evictions. And as regards this note, or this publication in the press, this was not done by FEGWA.
Questions about Mr. Campollo and Mr. Pinto. In requesting that the President issue a lesivo declaration in relation to contracts 143 and 158, did you in any way whatsoever intend to benefit Mr. Ramon Campollo?
Primero que todo.
First of all, I never received any order from a higher level authority to carry out all of the studies that the legal departments did and the whole process. I never received any order from a higher level authority. I never heard that Mr. Ramon Campollo, or I should say I was never pressured to favor Mr. Campollo. Indeed, Mr. Campollo was never within the sphere of FEGWA actions. I don't know him. I reiterate, I do not know him. I don't really know who he is. I've never seen him. I deny that any action with respect to the process on lesividad was done to favor Mr. Campollo or any other individual or institution. That was not the case.
About a plan that was put together by the Railroad Commission to remove squatters in the right-of-way to the southern coast of Guatemala City. and you were asked whether the reason that that plan was not implemented was because the government didn't have the funds in order to effectuate that plan, and you responded no. My question is, just bear with me, let me get my question out. My question is, what was the reason, to your understanding, that the squatter plan that was elaborated by the Railroad Commission was not implemented?
Okay.
Okay. First of all, I want to tell you that the Railway Commission was a commission made up of serious government institutions, and, logically, Ferrovías as well. And, as you mentioned, Mr. Pinto. I have read, in some way, that they did not believe that this was a serious activity, and I think that that's not the case. It was a totally serious activity. FEGWA did everything that it had to do to work on developing the Ciudad del Sur project, the rehabilitation project in order for the train to get to Ciudad del Sur. It was 38 miles. The economic question is revolving around this whole situation. Approximately 1,750 families of squatters were identified in the right-of-way from Puerto Quetzal to Santa Lucia, and that was the stretch that was supposedly to be rehabilitated. Of those 1,750, well, they were spread out all throughout that time. Now, a government institution undertook to seek housing projects to which they could be transferred. 3 places were identified, one in the Puerto San Jose, another near Escuintla, and the other in the proximity of Santa Lucia. Representatives of the Commission spoke with the owners of the projects and established a price that could be negotiable. Then it was necessary to contact the squatters' leaders. At a meeting of the Railway Commission, Vice Minister Gándara and Mr. Héctor Valenzuela indicated that they had gone to a meeting with the squatters and that they had convinced them to be relocated. After that, it was established that approximately 33 million quetzales would be needed to relocate the squatters in the new projects, where definitively they were going to have better living conditions than what they had at the time that we were dealing with the situation. After that, they indicated to us, Vice Minister Gándara indicated, that they had already located those 33 million for the eviction and the relocation. The economic issue was always a hotly debated one, but we already had a proposal. There was 33 million to carry out the eviction and the relocation of those persons.
Wasn't that plan effectuated to remove the squatters, if you know?
Bueno,
In that plan, it was necessary to do registry work, or to do cadastral work. I don't know how you would say that in English.
yeah, registro de propiedad.
Or a property registry or land registry of all of the settlements along the right-of-way. FEGWA did this, and it put the request to the property registrar of Guatemala, and it located all of the certifications so as to be able to present them to the judge. It was identified, or the judge was identified, and it was even thought that one could use a helicopter for the judge to examine the entire invaded right-of-way and for him to, and then the request for eviction was to be drawn up. The Minister of Communications sent an attorney, but with the last name Bravati, who was a specialist on evictions.
We were working in this phase, and let me tell you that to this end, Ferrovias helped with Mr. Hector Tortole, who owned a company that took aerial pictures, and we had the information already for the registry of all the property.
Questions for you, and we need to break. If you don't know the answer to the question, then that's fine. But the question is just, to your knowledge, why did the commission not proceed with the eviction of the squatter plan? That's the main issue that if you could just answer.
Okay.
Supposedly, Mr. Hector Pinto was the representative of the investors. And when we were already working on this plan, all of a sudden, I understand that, I don't know if it was Mr. Valenzuela or the minister received a note indicating that no agreement had been reached with Ferrovias for the railway project, and since there was no agreement with Ferrovias, the investors would be withdrawing from the table. And given this situation, we thought it was not appropriate to continue with the eviction plan, because if there was no railway rehabilitation in the short term, that is to say right after the eviction, the lands were going to be taken again, and that was the reason why the project was stalled.
No further questions.
Mr. Gramajo, you said that you carried out some evictions, not the big ones that we were just talking about, but some other evictions. When were they?
No recuerdo
I don't remember the dates, but I do remember that they were published in the Guatemalan newspapers, because that is an interesting piece of news in Guatemala when we have evictions of this sort. In general, the eviction of squatters usually lead to problems and some sort of violence, because the police is acting, etc. So we were lucky in the sense that we had police officials from several departments of Guatemala, and the police chief was very conscientious, and he attained this eviction without any sort of violence.
So we know that they were not violent, but we don't know when they were.
Not.
I don't remember the dates. We had two, but I don't remember the date.
What sort of funding was put into the relocation of the squatters on those occasions? How much money was spent?
En este lugar de.
Are you asking me how much money FEG was spent? FEGWA took their workers who are paid salaries by using the vehicles that belong to FEGWA. The National Police got to that place through their own means, and the same applied to the lawyers of FEGWA. It wasn't a major expense.
You said earlier on that there was expenses involved in the relocation of the squatters because they had to have somewhere to go. What happened on this occasion in terms of those expenses?
En este caso.
In this case, there were no expenses because It was quite a recent taking, and we hadn't thought of the relocation and the placement of these squatters somewhere else. We knew that these people were coming from a nearby town, and we carried out the eviction without further problems, and there were no extra expenses.
Dr. Gramajo, I'd like to sort of take us back to basics, if I may. My understanding, and I want to see if it is yours, is that prior to your assuming your position as overseer, there had been a contract numbered 41, and when you did the review, you, I think, found, but please tell me, that that contract never came into force. Is that correct, as you were reviewing these past contracts?
Así es.
That is correct. Contract 41 was the very first one for the usufruct of the railway equipment, and that contract included as one of the clauses that it had to be approved by government agreement, and since there was no government agreement for the approval, the parties decided to draft a new agreement, and this contract was considered terminated.
If you could turn, please, to your first statement, paragraph 11. We have been told by a senior employee of FEGUA that up to 2000, when the then president was about to leave office, that he both wrote letters to and personally came to the office of the president to try to obtain executive approval for that contract. Do you have any knowledge of that?
No, no la tengo.
No, I don't.
No tenía conocimiento.
I wasn't aware of that.
Would it surprise you to know that that is what we were told?
Sí, me sorprende.
Yes, it is surprising. I wasn't aware of this before.
In your review of the previous contracts, did you understand that contract 41 had been let for a bid, that there was a bid on 41?
Sí, es.
That is correct.
And contract 143, and then later in the same year in 2003, contract 158, were not submitted to a bid, as I understand it. Is that correct?
That is correct. However, contract 143 refers to the bidding terms of contract 41, but there was no bidding process.
You then, at that time, that there was no need for another bid since it already referred to contract 41, which had a bid, and it was simply a successor agreement incorporating many of the terms of 41?
No, we thought, based on our conversations with the lawyers, that contract 143 and expansion 158 had legal defects. We could not tie them to the bidding terms for contract 41 that had been held several years ago. Therefore, we could not attach that to that bidding process, and we thought that the contract had legal deficiencies. We could even say that it was illegal based on the opinion of the lawyers.
Then two subsequent contracts dealing with the equipment to 41, correct? There was 143, and then later in the year, 158. Is that correct?
Sí.
Yes, but what I'm saying is that the contracts had deficiencies, that is 143 and 158, and contracts 143 and 148 could not be linked to the bidding terms for a contract that had been carried out years ago. That was 41, but in contract 143, reference is made to the bidding terms, which is not correct.
To refer you back again to paragraph 11, you say in the last sentence of that paragraph, this meant that the contract had been signed by Fegua's former overseer who did not have the authority to do so. Which contract are you referring to there, and who was the former overseer?
This is referring to contract 143 and 148 and 158, and the overseer that signed these contracts was Mr. Hugo René Sarceño.
Saying here, I just want to understand that Mr. Sarceño, who was the overseer of Fegua, signed the contracts, but you and perhaps your legal department determined that he signed those improperly? Is that what you're saying here?
Sí, yes.
That is correct.
And in your discussions with Ferrovias, did you say to them explicitly that it had been an error for your predecessor, Mr. Sarceño, to have signed these, and therefore you needed to rectify that particular defect by getting the president to sign or by amending the contract on that specific issue, just on that issue?
Sí.
Yes. In the discussions we had with Ferrovias, we did mention that it was fundamental to draft a new contract establishing that the contract had to be authorized by the President of the Republic. It was one of the negotiation items that we included for the drafting of a new contract.
Do you have a copy, or perhaps your counsel would have a copy of the draft agreement you referred to? Would you be good enough to?
Just to clarify for the record, and just a misstatement, we are not representing Mr. You said your counsel. I'm just being
counsel
clear.
For.
Thank you. R50, R51, and R80 are the documents. R50, R51, and R80. I'm sorry. Yes. Yes. Respondents. Are they in those binders? I don't know. I didn't put those binders together.
I have it in this one here.
Oh. If you'd like, we can put them up on the screen if you have questions about them.
What I would ask, and perhaps counsel knows these documents better than we do, so that we don't have him reading every document, but what I'd like to know is if you could look at, let's start with 50, I suppose, if that's the first. And would you be good enough to show us where in the draft agreement you sought to remedy the lack of both a bid and executive approval?
Mr. Eisenstadt, if I could, just to move the process along, just if I could describe briefly what the documents are.
That would be useful.
As I understand it, R50, which is the document that's up on the screen, is a draft that was sent by counsel for Ferrovias to Fegua, and then R51 and R80 are drafts that went back and forth, I believe, from Fegua to.
Thank you.
So you know, This draft was not prepared or commented on by FEGWA. It was received by FEGWA. Is what we understand from the face of the document in the email.
Okay. Perhaps it would be more useful then to look at the documents that you sent back, since that is something that was prepared presumably under your control.
R51 would be one of them.
So would you be good enough to look at the document that's been referred to by as R51? And if you could illuminate what specific defects you were trying to correct in the original contract, please, and in particular the presidential approval and the bidding.
¿Podría tener una copia?
May I have a copy of the document?
Again, the copy that we have has some highlighting. It's our copy, but if it... Oh, you have it there? Great, thank you. I think we have a clean copy for the witness.
Está muy pequeño, no,
We have clean copies here also.
Necesito uno con una letra.
I need a document with a larger font.
Yes, would you be good enough just to refer to those particular provisions that deal with the legal defects that were ultimately the subject of LaCivo, the lack of public bidding and the need for executive approval? Would you be good enough to help the tribunal by showing us where in this proposal those are referenced? I see on page, just to help, this is the first time I've had the pleasure of reading this, but on page 5, at least in the English version, it says the contract shall be approved by executive resolution
Secretary Eisenstadt, if you'd like my input, I can give it. Okay, I'm sorry. It's clause 6 of the draft agreement. Clause 6.
Yes, sir. So please, just if you can refer us, this may be one, but I'm simply asking you, these are FEGWA documents. Please tell us where you were seeking to change the agreement or rectify the two errors that were the basis for LaCivo, which was the lack of a bidding process and the need for executive approval. Just please help the tribunal by showing us where those are here.
Dice sexta cláusula.
It says sixth term of the contract. The term of the contract is, and the number of years is not readable. And then in between parentheses, it says, in connection with the term of the contract, this shall be counted so that the term is the same as the one applied to contract 402, which shall be effective 30 days after the publication in the official Gazette of the Guatemalan government, and this agreement shall take effect upon the signing of the instrument. Once again, clause number 6.
Very simple question. Please refer the tribunal to the specific references that would correct the defects on the bidding process and on executive approval. Not the duration, but just those defects.
Okay. Una cosa importante.
An important comment is that this is the draft of the preliminary agreement, and some of the concerns by FEGWA are included here. It says duration of the contract, which shall begin 30 days after the publication of the executive resolution approving this agreement in the official Gazette of the Guatemalan government.
The need for a rebid, is that referenced in here?
En la página 4 hay una.
On page 4, there is handwritten text by the counsel for FEGWA, and she emphasizes the bidding terms.
Called for a rebid.
Consideramos que
We consider that that was one of the conditions that had to be met according to the attorneys.
I thought you answered Mr. Foster when he asked about a rebid, saying he asked you why you didn't rebid, and you said because there might be other bidders that came in. Am I incorrect in remembering that?
Afirmativo no es.
That was not the intent behind my statement. What I said is that based on the opinion of the council, this type of contract has to have its own bidding terms. And since the intent was to have a new contract for the usufruct of the railway equipment, the attorneys are telling us that we need to have bidding terms based on the law, and that is the legal advice. Therefore, it was necessary to have bidding terms, specific bidding terms for the new contract.
This draft seems to include things that go beyond the bidding terms and executive approval. For example, sorry again, it looks like it's paragraph 6, the one with duration. There's a reference to the amount of 1.25% of net freight turnover.
And Secretary Eisenstadt, I believe that's in paragraph 7.
Thank you very much. So are there certain terms in here that go beyond, including this, the basis for la cividad, which was the absence of a bidding process and the absence of presidential approval?
There's an important issue, which is the fact that this is a draft contract. This was being negotiated with Ferrovias' lawyers. These were proposals that we were putting forth, and we received proposals in return. This was not necessarily going to be the final document. We put forth proposals that we felt should be put forth, and we received the counter-proposals by Ferrovias. This is not the final agreement. This is a draft contract.
But is it the case that in the context of this new contract you were seeking, you were trying to reach a more comprehensive agreement with Ferrovias that dealt with a whole range of issues, including the terms of canon payments and other issues that went beyond the specific need that you saw for executive approval and for a bid, that you were seeking a more comprehensive agreement?
That is correct. We were trying to prepare a contract that met the expectations of FEGUA and of Ferrovias. The intention was at all times to negotiate so that both parties could agree as to the language included in the contract. That is why we put forth proposals, and Ferrovias also put forth proposals. This was an agreement that had more comprehensive proposals, but this was a draft agreement. Like I said, we were open to any suggestion, to any proposal by Ferrovias, and I understand that they as well wanted to receive our proposals.
If you would refer to paragraph 43 of your first statement, I think that reinforces this point, but I just want to make sure that I fully understand it.
Perdón, ¿qué párrafo?
What paragraph?
Paragraph 43, please. Now, this is, of course, dealing with discussions after La Cividad, not before. And here you mention the need to negotiate a comprehensive agreement aimed not only at rectifying the aforementioned contract's legal defects, but also at improving relations between Ferrovias FEGWA. Am I reading that correctly?
A ver,
Let's see, sir, Counselor. This makes reference to the meeting we had before the declaration of lesividad was issued. Please repeat the question, if you will.
Okay, were you, let me try to encapsulate it, both before lesividad was declared and after lesividad was declared, was FEGWA and the government trying to reach a comprehensive new agreement with Ferrovias that went beyond the legal defects and dealt with other concerns that the government had?
así es.
That is correct. We held meetings, negotiation meetings, before and after the declaration of lesividad was issued and published. It is true, we discussed other proposals, both by FEGWA and by Ferrovias.
Might it not been easier, at least in retrospect, to simply cure the specific defects that were identified with respect to 143 and 158, rather than tying them into a broader, more comprehensive renegotiation?
What we had to renegotiate was 143. 143 was an illegal contract, and a new contract had to be entered into. Since we were not able to reach an agreement in connection with the new draft contract and prepare a new railway equipment agreement, and we did not reach an agreement with Ferrovias, we considered that the contract was illegal. So this situation did not have to do with just amending 143. We were looking at preparing a new railway equipment contract without the irregularities that had been identified.
But the irregular, I'm sorry.
Can I have a try? That is an important question.
Yes.
Can I try and ask that question again? Because I don't think you quite understood, if I may say so, the point of Secretary Eisenstadt's question. There were two deficiencies in the original contract which made it illegal.
Sí.
Yes.
It's one thing to have a new contract which rectifies those deficiencies. It's another thing to have a new contract that completely renegotiates the terms on which the enterprise is going to carry out its business. Why didn't you do the first? Why did you insist on the second? Stick to a contract which just dealt with a new contract which just dealt with the 2 points of deficiency, and leave the rest to be sorted out later on in the context of a lawful railway operation.
Because we were not able to reach an agreement with Ferrovias. We tried on several occasions and meetings to reach an agreement with them, but we were not able to reach an agreement. We were unable to do that.
Ferrovias, if you'd said to Ferrovias, okay, we've discovered some legal problems with this, with the existing contract. First, it hasn't been ratified by the executive decree, and second, although there was a bid process, it didn't relate to this contract. Now we propose to fix those 2 points up. Ferrovias would have agreed to that, surely.
Probably it would have agreed, and those were the proposals that we put forth. We wanted to make the situation, some situations, more lax in favor of Ferrovias. If we look at the meetings after the lesividad, we see a series of flexible attitudes, both on the part of the government and of Ferrovias. We tried to do what you are saying, but no agreement was reached. There was no final agreement, in spite of the fact that a number of options were laid on the table to try and reach an agreement. The agreement was never reached.
I understand. Well, first of all, now we know why he's a professor and I'm just a secretary, because he can certainly more accurately state things. But was there, it seems to me that the reason that there wasn't an agreement, and this is not saying there's fault on either side, is because a whole range of issues that went beyond the bidding and the executive approval were being negotiated. Is that not the case?
When it comes to the lascivo nature of the contract, we didn't really tie into any other agreement to this. We only worked with the contract of usufruct of railway equipment. Although it's true there were other aspects that we wanted to negotiate, well, everything was centered, however, on the railway equipment contract.
Between 2003, when 143 and 158 were signed by Mr. Sorseño and Ferrovias in 2006, was there the ability of Ferrovias to use equipment pursuant to 143 and 158, notwithstanding the legal defects that you mentioned?
Ferrovias was using the railway equipment, but not on the basis of 143 and 158. Ferrovias had a letter that authorized it to use the railroad equipment, which was issued by an overseer before me. So Ferrovias used the railway equipment on the basis of an authorization issued out of a former overseer.
Now, you have said already that that former overseer did not have the authority to sign the agreement. Do you feel that these letters of authorization by him were also inappropriate?
You say lack what exactly?
Well, you would have already said that Mr. Sorseño signed the agreements but didn't have the authority to do so. So I'm asking now, since they were using equipment in your testimony pursuant to letters of authorization, were those letters of authorization from Mr. Sorseño or subsequent overseers before you came?
Yes, these were authorizations that allowed Ferrovias to use the railway equipment. There were not contracts, they were just authorization letters. By the former overseers. I wasn't involved in the issue because I did not issue any of those letters.
More than one of your predecessors who issued those letters of authorization?
As far as I understand, yes. I understand that Mr. Andrés Porras and I don't remember exactly whether Eddie Minera also did. There were authorization letters before my tenure in FEWA.
Do you think that that was inappropriate as you look at it from your perspective, that they shouldn't have given that those letters of authorization?
I don't think it was improper. I think it was a matter that had to do with the fact that, well, if a contract had problems that had been identified, well, what that showed was the goodwill of the officers of FEGUA at the time, the goodwill that they had not to block the use of the railway equipment by Ferrovías. This was evidence of good faith, in my opinion, and of cordial relations, because they authorized them to use their railway equipment.
Just a couple more questions, thank you. Just a couple more questions. First, okay. Okay, I think the President would prefer that we take a short break now, and I'll be at his pleasure to.
Since we have been going on for more than 2 hours, and also in deference to the court reporters and the interpreters, we will have a break now, and we reconvene at 11:30. And the witness should not be approached by either side. Thank you.
Thank you, Mr. Chairman.
We are going to continue the session this morning.
Thank you.
And Secretary, I start had a number of questions.
Thank you. As I understand it, the term lesividad means that something is contrary to the interests of the state. Is that an appropriate understanding, or perhaps if it's not, you might give me an understanding of what this term means?
As one who is not an attorney, I understand that lesivo is something that is against the interests of something or someone, in this case, the Guatemalan state. I could not give you any legal detail because I'm not an attorney.
Consider it from your perspective as having been at the time the overseer of FEGUA to be a consequential and important decision to declare something lesividad?
Sí, porque
Yes, it is important because one is carrying out the law to begin with, and in addition because it makes it possible for there to be, well, how could I say it? It makes it possible for others to learn or to find that in Guatemala it's also possible to respect the law and that one should respect the law. I do think that it is very important, a declaration of lesividad of this sort, because it's an important matter for the country.
Did you or your attorneys ever consider any other options to cure the specific defects, that is, the absence of a bid and the absence of executive approval, for example, going into court for a breach of contract, or anything that was perhaps less consequential than a lesivo declaration?
Recordemos.
Let's recall that initially the opinions issued by the Office of the Attorney General were already telling us that the contract was lesivo. If the Office of the Attorney General indicates to us that a contract is lesivo, then we have to follow the process. We cannot go back and make some other arrangement because there's already an opinion that is telling us that there is lesividad before going to seek a declaration of lesividad from the President of the Republic.
Second statement, Mr. Gramajo, paragraph number 6, please. You mentioned there, I believe, that instead of initiating legal actions to challenge the validity of equipment USAFRA contract 143-158, FEGWA tried to carry out negotiations in good faith in an attempt to rectify legal defects. Am I reading that correctly?
Sí, así es.
Yes, that's right.
So was there a consideration given to legal actions to challenge the validity of the contracts rather than a declaration of lesividad?
¿Podría repetir?
Could you please repeat the question so that I can be sure I'm understanding the context?
This mentions that instead of taking legal action to challenge the validity of these contracts, you tried to carry out negotiations to rectify them. I'm asking, given what you've said here, were there discussions that you had with your legal department or with others at FEGWA to challenge the validity of the contracts when you determined that negotiations were not succeeding, rather than take the step of lesividad?
Yes, we had some meetings, and we did have discussions on this. Nonetheless, since the attorneys indicated to us that if we found any defect in any of the contracts, our obligation was to seek the opinion of the Attorney General of the nation, and that is why we did that. Nonetheless, it is quite clear that before anything else, we sat down to negotiate with Ferrovias to try to cure these problems. No agreement was reached.
I understand that Ferrovias initiated some local arbitrations. Did FEGWA, on any of the issues here, initiate a local arbitration?
No recuerdo exactamente.
I don't remember exactly. Nonetheless, this whole context is not related to the problem of 143. This is a problem that we are dealing with specifically. I don't recall exactly whether arbitration was begun. I believe that arbitration was begun before the Arbitration Center of the Chamber of Commerce based on, well, I don't remember very well if it was Contract 402, but I don't remember exactly.
To look at your first statement, paragraph 16 and 17. This seems to reference a letter of April 12, 2005 to the legal coordinator of the Ministry of Communications talking about issues in dispute with Ferrovias, in particular the legal defects in the USAFRA contract. Is that your understanding of what this letter was about?
Sí.
Yes.
In paragraph 17, it appears that there were a number of communications with Ferrovias which again seem to go beyond the issue of a rebid and executive approval to include non-fulfillment of the railway refurbishing plan, issues related to the trust contract. So you were seeking here a sort of global comprehensive agreement, as I understand it. Is that a fair characterization of what you're saying here?
No.
No, that is not the case. While it's true that we had some conversations with the legal department of the Ministry of Communications, in those conversations, different topics were touched upon. But the question of the railway equipment contract was a very well-defined issue that did not affect the other issues that we were discussing. Logically, when we went to the Ministry of Communications, we would talk about all of the problems, including non-contractual problems that FEGWA might have. But the issue of the usufruct contract for the rail equipment was a specific issue, and it was treated specifically. Logically, in the context of the conversations that were held, other issues were also discussed, but each one was addressed specifically.
Let me close with trying to better understand this issue of executive approval. We have a term here after a famous book called Catch-22. I don't know if you've ever heard of that. It's an English, American term, perhaps. But it seems to me that you had a situation, as laid out in your letter of January 13, 2006, to which you've already referred, in which first you had Contract 41, which did not have executive approval, so it was abandoned, or it didn't go into legal effect, correct?
Así es.
That is right.
143 you tried again, 143 and 158, and it wasn't written to require executive approval. You said several times it expressly did not require that. Is that correct?
Así es.
That is right, even though it should have been an essential requirement given the type of contract. In the contract, it said in the text that approval by the highest level authority was not necessary.
Drafting these contracts, 41, 143, 158, who was drafting them? Under whose supervision? Was it FEGWA that was doing it, or the Ministry of Communications?
As I understand it, the ones who drafted the contracts were the Ferrovias lawyers, the ones who prepared the text. That is the information that I have. Of course, I wasn't there, but according to what I've been told by the lawyers, these texts were drawn up by the lawyers for Ferrovias.
Ferrovias drafted 3 defective contracts, and yet they were the ones who then came to you and said, they're defective and we have to change them. Am I missing something?
Es correcto.
That's correct. It is my understanding that they're the ones who drafted the contracts, and nonetheless, subsequently, they themselves tried to make contact in order to draw up a new usufruct contract.
They made a mistake 3 times, and then they came back and said, we realized we made a mistake 3 times, and this contract is going to be lesivo unless we correct our own mistake. Is that a fair way of putting it?
Yo creo que
I think that in the case of Contract 41, the only thing missing was authorization by the President of the Republic. I don't know why it wasn't approved. Nonetheless, in Contract 143 and 158, the contract was drawn up inadequately with the defects which subsequently were sought to be cured by drawing up a new contract. So, from the outset, in my view, I'm not an attorney, and based on the information that our attorneys told me, contracts 143 and 158 were drawn up with a substantial error or material error, and that is why, for us, they were illegal contracts.
Those attorneys, if they had now determined that this was so serious an error as to declare lesividad, why they had made the mistake in drafting the contracts themselves without this?
Logically, I didn't have such fluid communication with the Ferrovias lawyers so as to ask them this.
Yes, your own lawyers, they're the ones that drafted the contract. Did you say to them, why are you now saying that we need executive approval when you drafted contracts which didn't require that?
Tengo entendido.
It is my understanding that contract 143
Tengo entendido que
it's my understanding that contract 143 and 158 were not drawn up by FEGWA's lawyers, but rather they were drawn up by the other party's lawyers, and they were presented to the FEGWA overseer on that occasion. Indeed, I remember having had conversations with the legal counsel to FEGWA at that time, who indicated to the overseer Sarceño that he should not sign that contract because it wasn't correct. And overseer Sarceño didn't pay attention to that advice and signed the contract.
Uncertain about this. You're now saying that 143 and 158 were not initiated by FEGWA but by Ferrovias?
el texto, según tengo.
The text, as I understand it, according to what was communicated to me, the text was drawn up by attorneys for Ferrovias. That is what I understand. I repeat, I wasn't there. I didn't see it. I don't know if it was really them who drew up the contract, but according to the information that I was given, the contracts had been drawn up by Ferrovias lawyers.
Were you shown any document from the legal advisors to FEGWA in which they said to Mr. Sarceño, you must not sign this because it would be illegal to do so without executive approval?
No
I don't remember exactly. I think that I did read on some occasion a note directed to Overseer Sarceño by the lawyer. I don't remember the name exactly. Nonetheless, on some occasion, I spoke with this attorney, and he told me that, in effect, he had warned Overseer Sarceño that those contracts weren't proper and that he shouldn't sign them. Nonetheless, Overseer Sarceño ignored that warning and signed them. The reasons why he decided to do so, well, that I can't tell you.
We've heard testimony from one of your predecessors about efforts he made in, I believe it was the year 2000, to get the then president to sign the contract and was unsuccessful. Did you make any effort to go to the president and say, we have a defect here with respect to signature. If you'll sign this, it will correct that defect?
No
I did not do so because in the first case that you mentioned, Contract 41 did have all of the elements that were correct, except for authorization by the President of the Republic. I don't know why it wasn't signed by the President of the Republic at that time, but in the case of Contract 143 and its amendment to 158, I could not ask the President to sign an authorization for that contract, since in the text of the contract it says that authorization by the President of the Republic is unnecessary, and according to the lawyers, is not correct.
Thank you.
Mr. Horta, on the tribunal's questions.
Thank you, Mr. Chairman. And Secretary Eisenstadt, just for the benefit of the tribunal, since you asked about this, in relation to the lawyer who advised Mr. Sarceño, there is a statement of his on the record. It's a sworn statement by Mario Saúl Cifuentes. And then the document where he gave the Mr. Sarceño his conclusions about having reviewed the draft is document R4.
Thank you.
Dr. Gramajo, you were asked some questions by Secretary Eisenstadt about the draft R51, the draft potential new contract for the railway equipment that was being discussed between FEGUA and Ferrovías. And Secretary Eisenstadt asked you about the Section 7 of that clause relating to the canon payments. If we could put up, if possible, Kelby, C51, Section 7, I'm sorry, R51, Section 7, and C25, which is the contract 143, and just compare the text of the two to see if there are any differences. I believe the question that was asked to you was whether and why there were new canon payments being discussed in the context of this potential new railway equipment contract. So if we compare Clause 7 regarding the amount of the contract with the text of Clause 7, Clause 7, top hand document is R51, which is the document that was being negotiated between the parties after the execution of Contract 143 and 158. And then actual Clause 7 of Contract 143, 158, which is document C25. And the question is whether the canon payment there was any different between the two contracts from your estimation looking at both of them. They're up on the screen, sir, also. Oh, but that's
Sí, podría poner la versión en español.
Could you put the Spanish language version up?
Documents in front of you in Spanish. Camila, if you could assist.
Sí, pero con letra muy pequeña.
Yes, but it's a very small print.
Okay. Well, we can try to give them the copy of this. Okay, here we go. I think, sir, that they're bringing you copies of the agreements.
Pero tienen que ser con letra grande.
Sí, son grandes.
Okay.
Sir, in contract 143, which is C25, was the canon payment 1.25% of the net value of the freight?
Perdón, pero tengo R50.
I'm sorry, I have R50 and R51.
And R51, it appears he already has. We have a copy of C25 here, but it has a little bit of highlighting. I don't know if that's a problem. If it is, we'll look for one that has no highlighting. I don't believe the clause at issue has any highlighting. If the tribunal has no objection, we'll provide this to. Okay, here.
Mr. Foster has no problem. I think he's fine with that.
Thank you.
We have highlighting on the screen.
So, okay, now you have before you contract 143. And my question is, what is the what is the canon payment to be paid pursuant to that contract?
¿En qué parte está?
It is section 7. I believe I handed you the document with section 7.
Aquí dice controversias.
Here it says disputes. No, I'm sorry, that's 17.
Séptima monto de la negociación.
Seventh, amount of the negotiation.
Answer for the tribunal. What is the percentage of the canon that is to be paid, and on what basis?
1.25%.
1.25%. For the exclusive use of the equipment, said percentage shall equal 1.25%
Neto
of the net freight turnover, or net value of freight.
Look at contract R51, which is a draft agreement exchanged between the parties after the execution of 143 and 158, and tell us what is the canon payment that was to be paid pursuant to that draft agreement.
Seventh, amount of the negotiation. Excuse me.
Just tell me what was the net freight, I'm sorry, what was the freight, the canon payment, excuse me,
Okay.
that was to be paid.
Este
This percentage shall be 1.25% of the net value of the freight invoicing.
Is it the same freight in both the executed 143 and the draft agreement?
sí,
Yes, it is. It's the same.
By Secretary Eisenstadt about why it was that the parties were negotiating a number of issues in 2006 and leading to the eventual declaration, Lucio declaration regarding the equipment contracts. I believe Professor Crawford also asked you some questions about that. Do you recall attending a meeting in March of 2006 at the or with President Berger, at which representatives of Ferrovias were there?
sí, así es.
Yes, I do.
During that meeting, did Ferrovias ask President Berger to address a number of disputes between the parties, including the issue of the payments to the trust fund and the issue of their allegation that FEGWA was not sufficiently complying with its obligation to evict squatters?
Así es.
That is right. Those issues were raised by Mr. Posner.
Mr. Posner also raise with President Berger the issue of lack of financing with respect to the project and seek assistance from President Berger with respect to financing so that they could carry out the restoration of the railway?
I remember that at that meeting, what was discussed was that Ferrovías needed local investors to be able to carry out its railway projects. So that was one of the situations. Ferrovías said, Mr. Posner said that the railway projects needed investors in order to be able to carry them out. I don't remember anything else about this issue of investments.
One last question.
Thank you. If we could quickly put up R37, please, and if you have a Spanish version for, is this the only Spanish version we have here? R37? Okay, if you can put it up, perhaps maybe in both Spanish and English, just to save some time. And sir, while the document is being put up, for the record, R37 is our meeting minutes of negotiation meetings that were taking place between the government and Ferrovías, and this particular meeting minutes are for meetings taking place on the 4th of October 2006.
I object to the characterization of there being meeting minutes. These are internal notes of the government which were never given to Ferrovías.
Okay. Now, sir, looking at the section of the meeting minutes dated, looking at the section of the minutes that refer to contract 143, Kelby, if you could just highlight that. And also the Spanish version, and then my question. And again, sorry, for the record, these are dated 4 October 2006. During during this particular meeting, do you recall Mr. Jorge Sen expressing the view that from Ferrovía's standpoint, the drafting of a new equipment contract was of secondary priority given the plans to change the railroad system to wide gauge?
Sí, así es.
Yes, that is correct. As part of the meetings, we were proposing, as usual, to negotiate a new contract for the usufruct of the railway equipment without the defects that we had previously identified. At that meeting, Mr. Sen said that the drafting of a new contract was not fundamental because the future expansion plans for Ferrovías included wide gauge or standard gauge equipment, and that he was no longer interested in having this usufruct contract for the railway equipment.
You were,
no, thank you.
You were thinking because of the translation, the time that it needs to be interpreted.
Thank you, Mr. President. Dr. Gramajo, you told Secretary Eisenstadt that contracts 143 and 158, you said we could even say that they were illegal. And then at another time you said contract 143 was an illegal contract and it had to be renegotiated. And then another time you said that FVG was not using the railway equipment pursuant to contract 143. Will you please look at an opinion you got from the Attorney General of Guatemala. It is C-108 at tab 20. I'm sorry, I said the wrong thing. It's from the legal department at FEGUA, your legal department that you say you were relying on. Yes, tab 20.
And just so that the record is clear, I believe he testified he was relying on a number of legal opinions, not just this one.
We note your argument, David.
It's just a correction for the record, Alan.
You have that in front of you. Look at the portion that says regarding subsection A. And that first sentence reads,
Perdón.
I'm sorry, but I'm not sure this is the document. This is a request by the Attorney General of the Republic. That's what I have here.
he'll give you the correct document.
Tab 20.
Tab 20.
This is what's in tab 20.
Page 3. Okay. Inciso A es diferente cuando habla de inciso A.
Now, can you find the portion that says regarding subsection A?
Sí.
And
Yes.
the first sentence reads, the contract involving railway equipment entered into with Codifi on August 28, 2003, as documented by Public Instrument number 143, as amended by Contract 158, both authorized by Claudio Miriella Marroquin Luther, Notary, is currently in effect. And then the last sentence says, accordingly, the contract relevant to FEGUA's petition to the Solicitor General's office is documented by Public Instrument number 143, which is currently in effect. It is also under the terms of this contract that the usufructuary is using the railway equipment. Did I read that correctly?
Sí lo leyó correcta.
Yes, you read it correctly.
Now, you also asked some questions by Secretary Eisenstadt about whether or not the negotiations concerning the amendment of contracts 143 and 158, whether you desired a global solution to a number of problems. It's a fact, is it not, sir, that you wanted to obtain a return of certain non-operational historical assets that had been granted to FEGUA, to Ferrovias under the usufruct? Wasn't that one of your negotiating desires?
One of the negotiation points was for Ferrovias to return to FEGUA the historical railway equipment that was non-operational. Let us also remember that there is a cultural cooperation agreement between FEGUAS and Ferrovias that stated the same. That is to say that Ferrovias could return to FEGUA historical equipment that was non-operational upon request. But in spite of several requests, it was not possible to do so. Therefore, one of the concerns we had during our activities as overseers was to preserve some of the historical equipment, and one of the points being negotiated was in connection with the railway historical equipment.
And wasn't another point that you wanted to negotiate, didn't it have to do with the cannibalization of equipment? And what you contended was inadequate equipment appraisals?
Sí, así es.
That is correct.
And weren't you also trying to obtain a technical commission to be set up to determine the real value of the equipment?
Así es.
Correct.
And aren't these the things that you say in paragraph 20 of your first statement were the reasons that you failed to reach agreement in connection with the renegotiation of contracts 143 and 158?
Permítame, voy a buscar mi declaración.
Let me look at my statements.
Las tengo por acá, aquí las tenía, pero se ve que sí, sí. Ok. ¿Puede repetir el párrafo, por favor?
Would you please tell me again the page, the paragraph number?
In your first statement.
Sí, lo tengo a la vista.
Yes, I have it in front of me.
And my question is, weren't the matters that I was just bringing to your attention that you agreed were the subject of the negotiation, weren't they the reasons that you say that the parties failed to reach agreement?
Alan, if you could just clarify it as to time frame, if you would, please, so that the record's accurate.
Well, the time frame is the one he sets forth in his statement, 2004, when they were renegotiating.
¿Es cierto? ¿Es correcto?
It is true. It is correct. One of our concerns, as I was mentioning before, was the preservation of the historical railway equipment. And one of the negotiation points was for FEGWA to preserve the historical railway equipment that was non-operational, that is to say, that was not useful to Ferrovías, and that was one of the points that we were unable to reach an agreement on, and that's what I also mentioned.
And nowhere in paragraph 20, where you're discussing the reasons you were unable to reach agreement, do you say anything about the fact that there had not been executive approval of the contract, or the fact that no public bidding had been conducted? None of that's in there, is there, sir? Is it, sir?
En este párrafo.
In this paragraph, precisely that information is not included, but the meetings we held had the parties participate to discuss the non-authorization by the higher authority. So these were auxiliary negotiations that we were having with them.
You were also asked about the local arbitrations that Ferrovías brought against FEGWA. Did FEGWA ever consider counterclaiming in those local arbitrations for any alleged breaches that Ferrovías was in breach of any of its agreements?
I don't remember right now.
In any event, we do know that you never did file any counterclaim, don't we?
I don't remember.
You were referred to drafts of the revised contracts 143, in particular exhibits R51 and R80. Do you have any evidence to show that either one of those documents was ever sent to Ferrovías?
One of these documents was sent by Ferrovías to FEGWA for it to be discussed by the legal department. There is also a communication by FEGUA where we show that the document was received and the legal department of FEGUA is asked to examine the document and also to make the observations deemed pertinent.
Maybe my question was, if I could just ask it a slightly different way, Mr. President. The Exhibit R51 shows a number of comments on it by what appears to be someone in FEGUA. Do you have any evidence to show that you ever sent that commented upon document to Ferrovías?
Tengo en mis manos
I have here in my hands a copy of the email sent by Ferrovías Council, and I have my own notes to the legal department of Ferrovías, and I also indicated that the meeting to address this issue had to be held at FEGUA's location or at some neutral point, and that also FEGUA's attorneys had to attend, or the financial head, if possible. We corrected this draft agreement and we resent this to Ferrovías so that they could include their observations too.
To Ferrovías, but the question I'm asking you is, do you have any evidence, any written evidence to show that you sent it to them?
no tengo ninguna prueba.
I don't have any written evidence, but I assure you that that was the case.
Thank you. Señor Gramajo.
Mr. Gramajo, thank you very much for your statement. You can now leave the room. Thank you very much and have all a nice day.
We have two expert witnesses on the legal side. Our suggestion from the tribunal would be to break now and meet early in the afternoon, in an hour's time at 1:15. Would that be convenient to everybody?
Yes. Yes, from the respondent.
Yes, sir.
Okay. Very good. So let's break now, and we will reconvene at 1:15. Thank you.